Hi, good afternoon, everybody. My name is Andrew Hall. I am a senior counsel and shareholder with the Blake Law Firm located here in Encinitas, California. We are real estate litigation and transaction attorneys. And today I'd like to talk to you a little bit about receiverships, and in particular, how this powerful tool can be used by litigants to enhance their case and ensure recovery of money judgments or secured property. So a brief overview of what we'll be discussing today is what is a receivership first and foremost. So you have a understanding of what receiverships are and why they are put in place. Some examples of receiverships: the process for appointing a receiver through the courts, how to take advantage of the appointment of a receiver once a receiver is in place, and certain limitations on receiverships once they are in place. So receiverships can be a valuable tool for any litigant, but in particular for litigants who are secured lenders. So where you have a property that is securing your loan, it's important to have that property upkept and not go into a dilapidated condition. A receiver can be appointed to come into the property, secure the property, make certain repairs to ensure that the property remains in good repair, and that ultimately the secured lender will be able to use the property to obtain payment on their loan. So some examples of when a receivership might be a good idea, as I mentioned earlier, in a secure lending context for foreclosures, in particular judicial foreclosures, which can take a bit to resolve. It's important to make sure that the property is staying in a good condition, and that the borrower is not letting it become dilapidated or otherwise devalued. As that could have an impact on the secured lender's ability to recover their monies on their loan. Another example would be in an unlawful detainer, in particular one involving a commercial real estate or large apartment complexes. And oftentimes you'll see this used to help collect and manage, collect rents and manage the property. The same can be said in a lending context where you have a borrower that's not making payments to a lender, but is renting the property and collecting rents. It'd be important to get a receiver in place to ensure that rent money is going to the lender and not into the pocket of your borrower. A third example would be a business dispute. Disputes where partners are, for example, alleging mismanagement or self-dealing. Having that neutral receiver put in place would be important to ensure that the business keeps running along smoothly while those disputes are resolved. So one hypothetical scenario that I've touched on briefly already, but imagine you were a secure lender. Okay, you make your loan, and your loan is secured by a piece of real property, let's say. That property is abandoned by the borrower. Borrower stops paying your loan, and no one is there to secure the property, to ensure its upkeep, and to ensure that it maintains its value, which is important to the lender and being able to eventually collect on the monies loaned out to the borrower. So it's important to have, in this context, a receiver put in place to ensure that the property is secured, to ensure that there are locks in place, to ensure that property is not being raided. For example, if you have a commercial property where it's left unsecured, persons can take over the property, they can squat in the property, they can take items from the property. Having a receiver put in place to prevent this is important in ensuring that the property is properly maintained. One thing to be aware of if you are interested in seeking a receiver is that receiverships are considered a drastic remedy by the court. So what does this mean? This means that receiverships can only be put in place in exceptional circumstances after a showing of a compelling need. So it's a relatively high bar to have a receiver put in place. You'll want to make sure that you have a detailed factual account and chronology of why you're seeking a receivership and why this drastic remedy is necessary. Sometimes courts will appoint receiverships on an ex parte basis, though this is even rarer than a notice motion for receivership. In order to have a receiver put in place on an ex parte basis, there needs to be a showing that if the receiver is not immediately put in place, that there's a potential for irreparable harm or injury. Some examples of this would be if you have property where it's unsecured, where insurance isn't being paid, where there's a substantial likelihood that if the receiver is not put in place immediately, the property could be lost or destroyed. So in these situations, you would want to consider not only seeking receivership, but seeking it on an ex parte basis, which will allow you to have a receiver put in place in a matter of days instead of the weeks or months that it would take under a normal notice motion. Another consideration is that a receiver must be sworn in, perform the duties of a receiver faithfully, and must give an undertaking in an amount determined by the judge. So the undertaking is required to be paid by the receiver. And there's often times, especially on an ex parte basis, the applicant is also required to put a bond in place. So this is something that you'll need to consider if you're seeking a receiver. You'll want to have the bond process going so you can have that put in place, because a receiver will not be appointed until the bond is in place. So you want to make sure that is taken care of very early on, even before the application is filed, if possible. So what powers does a receivership have over the property or the estate? In short, anything that you include in your order to the court that the court signs off on. So it could be a very broad range of powers depending on the type of property and the need for the receiver being in the property in the first place. However, some common powers that we see receivers receiving are to take possession and manage the property, which includes securing the property, to bring in and defend actions involving the property, to employ attorneys or other persons necessary to maintain the property, to sell the receivership property, or to invest funds. And on a side note, it's extremely important when you're seeking the appointment of a receiver that you craft a very detailed order that allows the judge to clearly state what the powers of the receiver are. Because if a receivership or a receiver is not granted the power by the court, they're not allowed to exercise that power. So for example, if your receivership order doesn't state that the receiver is allowed to sell the property, then even if that is a compelling need, the receiver will not be allowed to sell the property. So it's extremely important to pay close attention to your order, what's in the order, and what the need for the receiver is in the first place. Once a receiver is in place, there are restrictions on the receiver. It's important to note that a receiver is an officer of the court. As I mentioned earlier, a receiver must be sworn in. So the receiver is subject to the continuing control of the court. Just because a receiver is allowed to do something at the beginning of the case, a judge can always change his or her mind and restrict the receiver's powers later on in the case. So it's extremely important to recognize that a receiver is a continuing obligation, and it's not something that's set in stone upon the initial appointment of the receiver. As I mentioned earlier, receivers only have the powers granted by the statute or the order of appointment, and then by subsequent court orders over which the judge has broad discretion of issuing. So again, a judge can change his or her mind. They can expand the scope of the order. They can limit the scope of the order. So the powers endowed to the receiver by statute and by the order are extremely important to pay close attention to on an ongoing basis. As I'm sure you can tell from the brief presentation today, receiverships are an extremely powerful tool, but there's also a lot that goes into them. They're extremely technical motions, and it's an extremely technical type of relief. So it's important to have an attorney on your side that has handled receiverships before and knows the requirements of seeking a receivership before getting in front of the judge, because it's a powerful tool that if used properly can help you with your case and ensure that your property remains secured and that your loans remain collectible. If you have any questions, please feel free to reach out to us. We're happy to answer them. And thank you for your time.